Welcome back to the channel. Today, we're taking you inside another real courtroom hearing where every decision could change someone's future.
One courtroom. Multiple felony cases. And by the end of the hearing, Judge Raquel West delivers decisions that leave defendants facing life-changing consequences.
Good morning, ma'am. Are you Ashley Broussard?
Yes, ma'am.
And Ms. Broussard, in cause number 25 DCCR 0175, you're charged with the third-degree felony offense of injury to a child from October 28th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand? And I have here on the computer a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year deferred probation, a $500 fine, and you would be required to follow all of the rules and conditions of probation. Also, I'm sure Mr. Kimler went over with you that that type of probation, if you're successful, means you don't have a felony conviction on your record. Do you understand?
Yes, ma'am.
You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that? And do you want to reject that offer and have your case set for trial? All right, we'll get that done. I also want to make sure, Ms. Broussard, that you understand that after today, I will not accept this plea agreement. If you change your mind to want to plead guilty, you can plead open to the court. It could be to some different agreement, but it won't be this one unless there's some new information that your attorney or Mr. Smith gets between now and trial. Do you understand?
Yes, ma'am.
All right, then I'll get it set on the trial docket, and Mr. Kimler will begin preparation for trial. You're free to go.
This was sent.
You-
That's Broussard, right?
Yeah. Mr.
Filed a
Kimler,
motion
you filed a motion about bond conditions.
And there was an interval between the events made the basis of this case and the arrest, I think 3 or 4 months, however long, when CPS was investigating the case where she had custody of the child, or at least was visiting the child. But
What?
with CPS.
I can't, y'all can't both talk at the same
With
time.
CPS supervision without any problems. Then when she was arrested, there was a condition of bond that she not have any contact with the child. CPS doesn't have any issues with her having visitation or contact with the child. We were just asking the court remove that bond condition because it's impacting her relationship with the child. And I think the child's development. How old's the child? 3 years old.
Give me just a second. Can you hand me that what I'm printing, please?
Who was the CPS investigator? If you have any questions for her, we can run it over.
Mr. Smith?
If Mr. Smith has any questions, run it over.
Now I'm asking what your position is.
It's opposed, Judge.
And again, I would just observe that there was about approximately 4-month period prior to her arrest. There were no incidents.
But that was,
There's a co-defendant in this case, Dalvius Williams. We had a hearing on this. I believe it was an MTRP on Mr. Williams. So you've seen the evidence in this case. I don't know if you recall it, but the child was 2 years old and nonverbal. And showed up at school Friday, everything was fine. Shows back up, misses Monday, shows back up Tuesday. The marks are there, and allegations are that those were the only people around her at the time.
And I would just observe that there was a CPS investigation subsequent to that where the child remained in contact with the defendant with no deleterious consequences reported.
no, what consequences?
Bad consequences.
No,
Harmful,
what's your word?
deleterious.
It's not going to be my word of the day to learn.
One of those SAT vocabulary.
It's been a long time since I took that. I'm trying to recall that hearing. I feel like that Mr. Williams was maybe more culpable with regard to the specific allegations, not necessarily not turn them in and things like that, but the actual physical.
And then when the police started the investigation on this, she lied to the police.
Allegedly, she didn't cooperate. We can agree on that. It was non-cooperative.
The only thing I will do, I will, modify the bond condition that you can have contact with the child, but it is only to be supervised. So, you are never to be alone with the child, period.
Is that through CPS supervision or is the supervision?
I don't, if CPS isn't involved, I can't order them to supervise. So y'all work on figuring that out, but there has to be another adult, some adult at all times, not a 16-year-old, an 18-year-old, someone.
Living with her grandmother, so I'm sure she.
Okay, perfect. Then I'll let you have visitation so that you can, obviously, I think this is something you will be able to get past. You'll be able to hopefully work towards more than just this, but I want to start off with me feeling comfortable with that until we figure out what's going on in your case. Okay?
In the interest of specificity, she's only to have contact with the child in presence of the grandmother. What's the grandmother's name?
Dana Williams.
Dana Williams.
She's
Okay.
only to have contact with the child in the presence of Dana Williams.
Okay, yes, that's the order. Thank you, Mr. Kimmler. Yeah, probably so. All right, sir, you're Michael Brasher.
Yes, ma'am.
And Mr. Brasher's case is set for trial to begin with jury selection on June 23rd. Obviously, Mr. Brasher, you were in custody last time you were here, and now you've made bond. And since you've made bond, I hate to move, your case is getting old, but if you've made bond, I expect you to try to hire a lawyer.
That is exactly what I brought here I brought some paperwork to present to the court if you see it. I want to ask for a continuance for that same reason.
So here's what I'm going to do, Mr. Brasher. I'm going to take your case off the trial docket and move it to a designation docket. I'm going to reset it about 30 days. You need to try to get someone hired before that court date.
Okay.
If you do, we'll give you a written reset notice today. Make sure you bring that to whoever you hire and they'll tell you what to do.
Okay.
If for some reason you cannot hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and then we'll discuss your options.
I have an attorney. I've spoken with him. He's given me a quoted amount. That's why I brought some of this stuff
Okay.
to show you.
I don't necessarily need to see it. I just need to, I'm going to see what you can do in the next 30 days. If for some reason, and I know you just bonded out, so if you possibly need more time, I understand. When you come back, let me know. If you haven't hired him or anyone else, make sure you visit with plenty of attorneys, bring me those names, or if you have one picked, have that information. If you've made payments, bring me that information, and then we'll discuss your options, okay?
I can absolutely. Would you like his name now? Or
Who is it? Yeah.
Mark Gonzalez out of Corpus Christi.
Okay. All right. Then make sure also that if that's who you hired, that Mr. Gonzalez knows that your case is old and that we will expect whoever you hire. Hold on a second while I'm talking, please, Mr. That's okay. Make sure whoever you hire understands that your case, if it's not worked out, is going to be set for trial pretty quickly because it's old. And so a lot of attorneys think they're going to get on and they'll have plenty of time. It's not going to be like that. They're going to get pushed. So you be sure and tell them that, okay?
And yes, ma'am. We've talked about that too.
Okay,
So,
perfect.
He understands that as well.
Okay, if you'll step over here in front of the clerk, she'll give you that reset notice. Thank you.
Copy of that.
You say here that your notice.
And also, until then, Mr. Matusky, you're obviously still on the case as begin to prepare possibly for trial, but I will take it off the trial docket at this point, just to give Mr. Brasher some time.
Yes, Your Honor.
All right.
Thank you, Judge.
Yes, sir. So we need Mr. Jeffries again, I guess, at some point. Oh, I don't have all that yet. Y'all hold on just a second. Good morning, ma'am. You're Renisha Payan?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
So
Ms. Payan, in cause number 24, DCCR 2107, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle, and that's from August 25th of 2024. And how do you plead to that charge? Speak up. Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? Speak up.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimmler?
Yes.
Do you fully understand them?
Yes.
And it's my understanding that you are pleading guilty open to the court, which means I can sentence you anywhere in the range of punishment. Is that your understanding?
Yes, ma'am.
So y'all signed the post-conviction waivers
Oh, I'm sorry.
on the admonishments, but
Well,
y'all didn't sign them on the, you said it wasn't an agree.
I don't even know if she waiving post-conviction waivers, if it's an open plea. I mean, after she's sentenced, if she gets probation, she could waive them then.
You're the one who marked them. No, she can't.
That's what I'm saying. Okay, I'm sorry.
That's why I'm bringing it up.
All right.
Y'all marked that it was a plea bargain, everything is all marked
Yeah,
incorrectly.
I shouldn't have had her sign the post-conviction. waivers.
Okay.
I'm sorry. It's forced to have it, Your Honor.
And then on that last page, I changed it with everyone's permission to the fact that it's not a plea agreement on the certification of right to appeal.
Thank you, Judge.
Right.
Okay. And I'll mark through. Okay. Okay, so I want to make sure you understand, you have an absolute, so first of all, I can sentence you anywhere in the range of punishment, which is between 2 years and up to 10 years in prison. I can consider probation. It'll all depend on information that's brought to me when we come back for sentencing. You have an absolute right to have a jury, which you're set for trial next week, starting trial on Monday, and let that jury decide if you're guilty or not. And then if they find you guilty, you can leave your punishment up to that jury. If we go forward this way, then you're waiving that. And is that what you want to do? Okay, state, do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Ms. Payan is not competent?
There's none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Kimmler. He will present it to me on your behalf when we come back.
Yes, ma'am.
All right, you can, on your way out of the courtroom, stop and talk to probation. She's at that desk right there. Okay?
Discovery, right?
Yeah, Discovery. All right, sir, again, you're Jerry LeBlanc,
Yes, ma'am.
and will your client waive the formal reading of the indictment in each case?
We do, yeah.
I'm number 2.
Hey, y'all, I'm still going. Sorry. Let's see. Mr. LeBlanc, in cause number 21-38605, you're charged with the state jail felony offense of theft from August 27th of 2021, and how do you plead to that charge?
Yes, yes,
Are you pleading guilty freely and voluntarily?
yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes,
And then in cause number 40408, you're charged with the state jail felony offense of abandoning a child from August 27th of 2021, and how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jeffries? The paper on the computer? Do you fully understand them?
yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases is for a cap of 15 months in the state jail prison, which means if I follow the agreements, I cannot give you more than 15 months in state jail. I can give you 15 months, I can give you less. It'll all depend on the information that I get when we come back at sentencing. You have an absolute right to have a jury come in and determine two things. The first is determine if you're guilty or not, and then you could leave your punishment up to that jury if they found you guilty. If we go forward this way, you're waiving that and leaving it up to me, and is that what you want to do?
It's not, it's, yeah.
I don't understand.
Cases are together, concurrent.
If I give you prison time in each of these cases, it would run concurrently, which is together at the same time. Okay. State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. LeBlanc is not competent?
No.
And also, Mr. LeBlanc, do you understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case? Did I already do that?
Yes.
It's admitted. Okay. I'm going to find, Mr. LeBlanc, that you entered your pleas of guilty freely and voluntarily in each case. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases. Then we'll come back at a later date for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Jeffries. He will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay, we'll see you back at sentencing.
Thank you, Your Honor.
Thank you. You're all free to go. Good morning. Are you Christian Boutte? And give me just a second. All right, and will your client waive the formal reading of the indictment in each case?
It will, Your Honor.
Did we, did I do something before on these? Somehow I have a prior version saved. So maybe I accidentally did it before. Sorry, give me just a second. I don't know why I would have done that. April 14th. On
the indictment?
Yeah, 2078 on the indictment. So, all right.
I have to go back and look at
Well, do y'all want to delete one, or can you? It doesn't matter, because I'm not making any notations on it. He's pleading to the indictment, correct?
Yes.
Nothing different. All right, so, Mr. Boutte, in cause number 24, DCCR 2078, you're charged with the third-degree felony offense of forgery of a financial instrument from August 21st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? And then in cause number 24, DCCR 2079, you're also, in that case, you're charged with the state jail felony offense of forgery of a financial instrument from May 7th of 2024. And how do you plead to that charge? Speak up, please.
Guilty.
And are you pleading guilty freely and voluntarily? And because you actually did what they charged you with? In each of those cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've reached with the district attorney, that you will be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
And it looks like the agreement that you've reached in each of your cases, in the third-degree felony, which is 2078, you've reached an agreement for a 7-year deferred probation. There would not be a fine. There would be restitution to be determined between now and when we come back for sentencing. Is that your understanding? And in the state jail felony case, the agreement's for a 5-year deferred probation. Same thing, no fine, and then any restitution would be determined between now and when we come back for sentencing. Is that also your understanding? State.
Sorry,
Yeah,
just to let the court know, we do have, and we have discussed some subrogation documents. We just want to double check prior to the PSI that Natchez, what did Natchez have to pay, what did this insurance company have to pay to write it? That way it's going to be pretty substantial, upwards of $60,000.
Okay, thank you. All right, state tenors number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Mr. Boutte is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your pleas of guilty in each case freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report that will give me more information about you, your cases, and then we'll come back later for sentencing. It'll also give everyone time to figure out that restitution for sure and who it needs to be paid to. You need to stop and talk to probation on your way out of the courtroom, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Mr. Stewart, you tested positive for THC, methamphetamines, and amphetamines, which is obviously a violation of the condition of your bond. When was the last time you smoked marijuana?
About a week ago, somebody,
When's the last time you used methamphetamine?
checked about a week ago.
All right, so Mr. Stewart, obviously, as those are violations of your bond, what does his bond set at right now? Let me see if I can find it too. Give me a second. Five. So, Mr. Stewart, I'm going to raise your bond because you violated, obviously, the conditions of it by using illegal substances. I'm going to raise your bond to $20,000. A condition of that bond, if you make it, is that you will be required to have a drug patch on at all times. You will have 24 hours from the time you're released from custody if you make that bond to get the drug patch on. You will have to go get that changed every 2 weeks. If it tests positive and you make that bond, the bond's going to go up and you're going to be back in jail. You're using drugs 1 week before you come to felony court while you have go back with the bailiff. Morning, Mr. Smith. Morning. Good morning, sir. Are you Brian Berrier? And Mr. Berrier is charged with, hold on, I can't even, something different than normal. Placing a serial number with intent to change identity, a third-degree felony from January 6th of 2023. And Mr. Smith, what is the announcement?
You know, we progressed to the point with this discovery that we know that this is not going to be a trial.
Okay.
I would like one more setting. I believe this is our first setting.
Oh, yeah, you were hired in April.
To discuss
Sure.
disposition.
All right, any issues?
No, Your Honor.
So I'm going to reset it about 30 days. Make sure you stay in touch with Mr. Smith. Will visit with the district attorney between now and then. Y'all can visit, and we'll see if we can get an announcement at the next court date.
Thank you.
All right, you're free to go, sir. And Mr. Smith, you also have Fabian Hall, 24 DCCR 0758. Good morning, sir. Are you Fabian Hall? And Mr. Hall is charged with injury to an elderly, child, or disabled individual. And Mr. Smith, what is the announcement?
Your Honor, this is, I believe, our first setting on the case. But I have talked with Ashley, and I'm asking for one more resetting. I'm trying to get into a further discussion concerning the culpable mental state.
All right, so any issues? All right, I'm going to do a normal reset. Obviously, you haven't been on that long, but it has been going on for a little while. So if you can try to visit with Ms. Malfino, make sure you stay in touch with Mr. Smith. So we'll see if we can get an announcement at that next court date. All right, thank you. Good morning, sir. Are you Michael Anthony Thomas?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge.
Mr. Thomas, in cause number 23, DCCR 0530, you're charged with the second-degree felony offense of indecency with a child by sexual contact from October 1st of 2019. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a cap of 4 years in prison, which means you'll be leaving your punishment up to me. As long as I don't give you more than 4 years in prison, then you can't appeal. If I can give you 4, 3, 2, I can consider probation. It'll depend on all the information that I receive at a sentencing hearing. You have an absolute right to have a jury come in and determine 2 things, if you're guilty or not, and then if they find you guilty, what your punishment is. Your case is actually set for trial to begin next Monday. So if we go forward this way, you're waiving the right to the jury, and you're going to want me to go forward this way, and is that what you want to do?
Yes.
Do you also understand that a plea of guilty or no contest, if you're not a U.S. citizen, may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? In addition, did you do the sex offender registration paperwork?
No, we did not.
So I'll go through it, and then before you leave today, make sure and get that done. And so also, do you understand that as a result of this plea, you will be required to register as a sex offender? All right. State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you are mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing, so the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Lewis. He will present it to me on your behalf when we come back. And make sure y'all get that signed. And do you have your discovery? Okay, all right. So you can visit with probation, but don't leave. Also, you're going to need to sign one more thing on the tablet with Mr. Lewis, okay? Good morning, ma'am. How are you? Good. Good morning. Are you Isaac Talley?
Yes, ma'am.
And Mr. Talley is charged with evading arrest or detention with the use of a vehicle. This is 24 DCCR 1997. And what is the announcement?
Your Honor, I have met with Mr. Talley and his grandmother. I'm just waiting to get video so we can review the video.
All right.
We'll be ready.
All right. Any issue?
No, Your Honor.
So,
I'm more of.
Thank you. I'll reset your case about 30 days. As soon as Ms. Holmes gets that information and that discovery of the video, I'm sure she'll call you. You need to go in and visit with her so you can see that. And then we'll get an announcement on what you're going to do with your case next court date. Okay, you're free to go.
Thank you.
See, Deontay Randolph, 24 DCCR 1923.
Email you.
Okay, thank you, ma'am. Can't believe it's already June. I feel like I just started writing May.
Yes. It's fine.
And will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Randolph, in cause number 24, DCCR 1923, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon, and that's from June 15th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Randolph's not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so the probation department can do a pre-sentence report. Will give me more information about you, your case, and then we will come back later for sentencing. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right there. All right, we'll see you back at sentencing. Good morning. Are you Albernica Conning? And Ms. Conning, you were previously in court and entered a plea of guilty to aggravated assault with a deadly weapon, second-degree felony. I've received the copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, Your Honor, we have.
Are there any additions or corrections?
Not from the defense, Your Honor.
No, Your Honor.
All right, Ms. Conning, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 10 years. You are ordered to pay a $500 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And at the end of the probation period, the case will actually be dismissed if you successfully complete it. The other side to that, however, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sentenced to prison for anywhere in that range of punishment, which is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
Part of your probation, the conditions, is that you have absolutely no contact, obviously, with Anaya Johnson, Nikki Lawrence, Lyric Lawrence, and Deanna Darjean. Do you understand? That doesn't mean just in person. That means any contact or communication. No sending messages through DMs or any social media, emails. No telling other people to tell them things. Stay away from them. Steer clear so that you don't end up back here in trouble and going to prison over anything like this. Do you understand? Also, you are not to be anywhere near the Regent Street apartment complex in Beaumont. You understand that as well, right? Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I will be signing dismissals in cause numbers 24 DCCR 1574, 1576, and 1577 as part of this agreement. If you just need to have a seat here in the courtroom, and then probation's going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, ma'am. See, Ms. Holmes, Christian Butte, 2 cases. Good morning, sir. You're Troy Hunt.
Yes, ma'am.
And Mr. Hunt, in cause number 24, DCCR 1481, you were previously in court, entered a plea of guilty to unlawfully carrying a weapon in prohibited place. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes.
Any additions or corrections?
No.
Judge, I would just like the record to reflect, please, as there was some confusion at the last setting about the forfeiture. The state does not ever agree to forfeit a weapon to a defense attorney. So what we have done is ask the court to sign the forfeiture, so the state is requiring the forfeiture of that weapon. It's my understanding the defendant has conveyed an assignment to Mr. Adams. I'm not part of that equation, but our intention was just to forfeit it for that order.
And I filed a motion to release the evidence.
Yes. Did we print that out? I remember looking at it on my desk. So you have no objection to me signing the forfeiture, and then I can sign the assignment. I think I saw that at some point. Hold on, let me find it.
We worked it out.
Let me get that pulled up and printed out.
I'm sorry, Judge.
No, it's fine. Let's see. It should be printing. There's that. Okay, so I will assign the forfeiture, and I'm about to sign the motion, the order releasing the evidence. Anything else before I go forward with sentencing?
Nothing.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 2 years. You're ordered to pay a $200 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you successfully complete the probation, at the end, the case will be dismissed. You'll never have the felony conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, you could be found guilty, so you would then be a convicted felon, and you could be sent to prison for anywhere in the range of punishment, which is between 2 years and up to 10 years in prison. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up to her desk when she's ready to go over all of your paperwork. All right, good luck to you, sir. And I've signed both of those.
Good luck, thanks.
And Mr. Adams, you have a Michael Spain Jr. Good morning, sir. Are you Michael Spain Jr.? And Mr. Spain's charged with aggravated assault with a deadly weapon. And Mr. Adams, what is the announcement?
The announcement, Judge, is this is just our second time here. I did speak with Mr. Coleman. My client has some stuff that he needs to get to me that he hasn't got to me as of yet. So we just asking for one reset, and then on that one, I can tell you whether or not it's going to be a plea or trial or whatever. But I do not want to put it on the trial docket, and I told Mr. Coleman that I did not want to put it on the trial docket.
Sure. All right. So I'm going to reset any issues, Mr. Coleman?
No, Judge.
I'm going to reset your case about 30 days. Mr. Spain, it's very important that if you have some information that you need to get to Mr. Adams, you need to do that quickly. Get that done this week so that he then has time to review whatever information is, to get it to Mr. Coleman. They can visit about it. Don't wait till right before court because then they're not going to have time to visit about it, okay? All right. You're free to go. Stay in touch with Mr. Adams. He'll let you know when you need to be back. All right, Mr. Jones, you tested negative. Obviously, that's a good thing. So I'm going to give you this opportunity today, even though I don't love the facts and kind of what was going on, and give you a chance, hopefully, to change your life, and you'll be able to live like the rest of us and not go to prison, okay? So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of unlawful possession of a firearm by a felon. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but probate that for 5 years. So you'll be on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. One of those is going to be, and I know that you're 37 or 38? 37. All right. You need to get a few things. You need to get a driver's license or some type of ID. You also need to get a GED, and that's going to be part of your probation. That's only going to help you get better jobs so you can be more successful. You need to get that process started within 30 days. So talk to probation. They'll let you know what you need to do. Most of it's online, but you need to get that done, okay? If you do everything that you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over, and you will be able to serve your sentence out while you're on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you'll be facing that 10-year sentence that you've already agreed to. Do you understand? I'm handing you two things. The first is the certification showing that I followed the agreement that you made with the district attorney. Sir, be quiet. That I followed the agreement that you made with the district attorney, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Obviously, you know this, but I'm required to read this to you. Possession of a firearm, because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. You just need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. Good luck to you, sir.
Thank you, Your Honor.
Thank you. What's his name in the bag? It's about to go.
Is that an initial document?
No, I'm just going to refocus. That, it doesn't show a state's attorney on that one.
Wait, hold on, I just got it. I just put it in.
The PC on that one,
Hold on.
the high-speed chase was crazy. I wonder whose it is. I mean, like 100 miles an hour down 105. They went from here to Hardin County and back and jumped out and ran in the woods and threw out drugs. So, all right, Mr. Johnson, come on up. Mr. Johnson, in cause number 24, DCCR 2265, we've already gone through this, but you're charged with evading arrest or detention with the use of a vehicle. I have reviewed the pre-sentence report in your case. Based on that report and the fact that there is an allegation, obviously an allegation of a high-speed, very dangerous chase, but in addition to that, there's an allegation that drugs were thrown out of the vehicle during that chase, and that's why I ordered the drug test this morning. It's now 11 o'clock. I ordered this drug test prior to 9 o'clock. You have not been able to go or refusing to go to the restroom. Based on that, I am going to find that I'm going to assume that you are positive and that it is in the best interest of our community that I raise your bond, which is currently set at, give me just a second to figure that out.
It was at 10,000.
10,000?
Yes, ma'am.
I'm going to raise your bond in your case to $30,000. A condition of that bond, if you make it, is that you wear a drug patch at all times. You will have 24 hours from the time you are released, if you make that bond, to have a drug patch put on. Your bondsman can let you know where to do that. You have to change it every 2 weeks. If it tests positive, you would be right back in custody, obviously. If it's not testable, then it's also going to be considered a positive drug screen. You can go back with the bailiff.
Can I say anything right now?
Not today, not.
Judge Raquel West oversees a busy felony docket with fairness and firm accountability, ensuring every defendant understands their rights and the consequences of their choices. The hearing features guilty pleas, bond hearings, and key sentencing decisions. But the biggest moment comes when a defendant's bond is increased after alleged bond violations and concerns raised during the case. Judge West makes it clear that second chances come with strict conditions, and failing to follow them can lead to serious consequences.